Good afternoon and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Torpy. To my left is Judge Evander. We have both criminal and civil cases on the docket this afternoon. 15 minutes per side on the criminal case, 20 minutes per side on the civil cases, and the appellant can reserve as much time for rebuttal as they choose. If you let me know how much you want, we'll try and help you keep track of that time. Make sure you have your phones turned off if you've got them, please. And the first case is State versus LIBURDI.
May it please the court, counsel, good afternoon. My name is Kelly Neal and I'm here on behalf of the appellant, the state of Florida. I'd like to reserve 5 minutes for rebuttal, please. The state is appealing an order of the trial court which granted Mr. LIBURDI's motion to suppress evidence that was found in his apartment.
Nealon, did you file a reply?
No, I did not.
Okay, was that some strategic decision on your part?
Yes, there was already oral argument requested, and I figured I had sufficient facts set forth in my initial brief.
Well, I would have found helpful your response to the issue of whether there were material omissions in the affidavit.
The trial court,
in particular, about the prior inconsistent statements that the informant had made.
well, first, the trial court didn't find that there were material omissions in this.
Yeah, but the trial court didn't address that issue one way or the other. Right?
Correct.
Yeah, so
Correct. And as
you know that could be a basis for affirmance since it was raised in the motion to suppress and it was addressed at the hearing, right?
And as I did note in my brief, that yes, he did give several inconsistent statements, but within 24 hours of his stop, his attorney contacted the federal agents. He went to the sheriff's office with his attorney and voluntarily, he was not even in custody when he gave all these.
I understand the explanation for that, but the issue in my mind is whether the material misstatements that were made would have been important to the magistrate who issued the warrant. In other words, reliability of the informant is an issue for the magistrate issuing the warrant, isn't it?
Yes, it is.
And doesn't the magistrate have the right, and doesn't the police have the duty to tell everything to the magistrate, the issuing magistrate, that they know that would bear on the reliability of the informant?
I don't think, based on the particular facts of this case, the fact that the man gave several different stories while he was standing on the side of the road right after he was first pulled over, and then when he was sitting in the patrol car, when he was later released, and with the next day came in with his attorney. I mean, these are statements
do you agree with me as an abstract legal proposition that the police officer who makes application for the warrant has a responsibility to tell, in his affidavit, to tell the issuing magistrate all information that bears on the reliability of the informant?
I think it does, but I think you have to look at it in the context of when this statement was made. This was a police officer that was drawing up this affidavit.
So you're arguing that this would not have been material?
Exactly.
Yeah.
Well, would you agree that, although there may be argument about the extent, that the fact that the informant gave several inconsistent statements would, under the facts of this case, reduce the reliability of his statements?
I don't think so at all. I mean, what suspect doesn't...
Do you think if he had said, given this right off the bat, that would indicate the same amount of reliability as giving 4 or 5 inconsistent statements before giving this one? Is that what you're suggesting?
I'm sorry, I didn't...
Are you suggesting that's equally reliable, whether he gave the final story right off the bat as opposed to giving it after 4 or 5 prior inconsistent statements?
The circumstances under which the final statement was made, yes. I think that makes it entirely reliable. This would have been admissible in a trial court because statements against penal interest are so inherently reliable. This was not a person who said, I know someone who's trafficking drugs because I heard about it from such and such a person.
You had an informant say, okay, yes, I am working for Mr. Smith. He's the one that supplied me with the money, and he's the one that makes the profit on this transaction. And then a day later, he says, the same informant says, well, I lied about that. It wasn't Mr. Smith that was my co-conspirator. It was Mr. Jones. Certainly the issuing magistrate wants to know, has a right to know, and should know all of that information, right?
Again, under the facts of this
They're
particular...
both statements against penal interest, but they implicate two different people, and you know, it bears on the reliability of the information that has been revealed, right?
Well, and then they went to the apartment in Orlando. Let's not also forget this man did have $103,000 on him. The agents then went to the apartments in Orlando, found out that the two people that he named, Mr. Carbone and Mr. LIBURDI, both had apartments in that building. They both drove the kind of cars that he said that they did. I mean, he gave very, very detailed statements about this. And again, this was on the advice of his attorney. His attorney went to the law enforcement with him to give this statement. This is not someone who just, was in custody for 20 hours and finally relented. Okay, fine, I'll give up my buddies. Again, he was not even in custody. He was let go after this happened. So I just think that based on these particular facts, and not as an across-the-board finding, but that these were not material omissions in this affidavit. Which leads me to the second issue then, which the trial court found that there was no nexus between the facts in the affidavit and the residence that was searched. Now this is...
established in the affidavit that the 2810, that was his apartment? The
Correct.
Apartment. That was clearly established in the affidavit.
Yes, well it said...
Was it established that it was his principal dwelling?
Well, no, it was, they did an Orlando Utilities Commission check, and they spoke with the manager, who said that, that he lived there, Carbone lived there, and they were friends.
But was it established, asserted that it was his principal dwelling?
That, I don't think it was asserted that it was his principal residence.
Okay. I mean, some of those nexus cases are situations where the court allows an inference that the instrumentality or fruits of the crime, that most people would keep those items in their principal residence. Do you see a distinction in a circumstance such as this, where this guy at least had two apartments that we know of that he had some sort of a connection to, the one downstairs and the one upstairs, and he might have had many others? Does that bear on the nexus issue, do you think?
No, I think it would make it even a stronger argument for the nexus, because you have a lesser, I mean, the thing with the residence is because of your expectation of privacy in your residence, and if it wasn't his primary residence, then that would not even be a factor that went into play here either. So, I mean, he did...
Didn't I write that case that had to do with...
Weil.
Yeah, Weil.
Yes.
And I thought, as I recall, I haven't really studied it like you have, but as I recall, what we said there was, it's a reasonable inference that somebody is going to keep these things. In that case, it was instrumentalities of the crime, that they're going to have a place to hide them, and that a logical place is their residence. And that's a reasonable inference, and that satisfies the nexus requirement. Isn't that what we said there?
Yes.
In that case?
Yes.
Okay.
And in Beasley too, which I think just cited.
Here we know he had one place where he kept the drugs and money, but it was a different place. Here we know that he had a place where he was keeping the drugs and the money, but then he had his residence up 10 floors above this place. Is that a distinguishing fact, do you think?
I think it makes it even stronger. He didn't even have to leave the building to go to the place where he lived and could store his money, the extra money, have a safe up there, whatever, and enjoy the fruits of his crime as well. I mean, a lot of these cases, it's, they follow the defendant from the
It sounds to me,
stash.
it sounds to like the agent that he was using 1810 to keep his drugs and money because he didn't want the police to find him in his his own apartment. I mean, it's.
Correct. And that apartment was in Mr. Carbone's name, and.
1810 was.
Correct.
Yeah.
And the manager said that Mr. Carbone and Mr. LIBURDI were friends, and that they both kept their cars there, and in order to really link Mr. LIBURDI to this trafficking thing, aside from the statements of Mr. McShee, was a search to see if there, to find evidence that he was trafficking out of the other apartment in this case.
What they find in 2810, is that in the record?
It is in the record. It's like on page 121. I think it was 45 pounds of marijuana. I put it in my brief, exactly what they found in there. But there was a money counting machine, there was a couple different packets of cash, a bag with cash in it, kind of like the usual things that are found when police do searches like this of residences and based on the nexus between the drug stash house. So I see I'm into my rebuttal time, so I will reserve the remaining time then. Thank you.
May it please the court, Stuart Hyman here on behalf of Mr. LIBURDI, along with Warren Lindsay, who's seated at council table. It's our position that the circuit court...
Could you zero me in on what the material omissions were? And I really don't want to hear about what the U.S. attorney did or didn't do. I'd rather talk about the other.
Well, I think, as the court pointed out previously, that the statements, the inconsistent statements, there's five, that only the sixth version was ever included in the affidavit for the search warrant. There were five previous versions that were all different that were never included in there.
I want you to tell me factually what they were. What was the inconsistency?
Well, on the first statement was when he was asked, Mr. Mitchke was asked if there was any currency or drugs in the car. He told the officer, no, there's nothing in there. And he had also told him that he had flown to Orlando when in fact the officer found a citation that indicated that he actually had driven to Orlando. Then when they brought the dog out, and when the dog alerted on the car and found the items, the money in particular, then Mr. Mitchke said that he was in the car business and he had been selling cars and he'd been accumulating this money for a period of time. And then he changed that to, there was the Miranda warnings were read to him, and then he came up with a third version of where the money was being kept and who was keeping it for him. And then there was Deputy Rawls, who also heard that Mr. Mitchke said that he was bringing the money from South Florida as opposed to Orlando, which was, I think, version number 3. And then version number 4 was when the DEA agent arrived, and he again went back to that he was selling cars and he was making this money selling cars. And then when the DEA agent informed him that giving false statements was something that he could be potentially prosecuted for, he then said that there was an individual in Colorado, C. Muscle, who ended up being Chris, who was the one that was keeping the money and the drugs and sending the drugs to Orlando, excuse me, and they were being kept at C. Muscle's mother's house. And then after he was released that day was the 6th version that came up. So 5 versions were given on the day of the incident. But I also think it's kind of important when you're talking about leaving things out of the affidavit. The affidavit for the search warrant, the officer said specifically, no information relevant to the target premises has been withheld that would be of exculpatory or mitigating nature. So our position is there was an affirmative misrepresentation in the affidavit for the search warrant because of the fact that he's saying there was no mitigating circumstances, even though there was all these statements. The other portion that was left out of what we submit was left out of the affidavit was the fact that Mr. Mitchke was apparently given immunity from prosecution, and that was never put in this affidavit. And as the court noted, veracity of that is even under Gates has always been extremely important in the affidavit.
Why was he given immunity, though, vis-a-vis the day where the magistrate signed the warrant? Didn't the granting of immunity occur after the warrant was issued?
It was after he was stopped where they gave him immunity. The day that he was stopped, he had confessed to, at the very worst, there was not paying taxes on the money. There was all kinds of different charges.
I think what Judge Evander means is had he been formally offered immunity prior to the execution of the warrant or after?
Nobody knows.
It's not in the record.
Everybody just said he was cooperating. That was about all I think we got on the suppression.
Now, a lot of the cases that you cite, I didn't read all of them, about material omissions and the reliability of informants dealt with confidential or anonymous informants. Are any of those cases in which the information comes from either a citizen informant or a co-conspirator?
I did cite one case, which was cited in another case out of Delaware, called Wilson versus State, which was 314 Atlantic 2nd 905, at page 907, where the court was discussing the informant in that particular case, which is analogous to this case, that Mr. Mitchke was not an average law-abiding citizen doing his civic duty when he provided this information. He
was an identified informant.
He was a confessed law violator who was presumably cooperating with the police at the time. So I wouldn't classify him as your normal civic citizen giving information. Normally in a search warrant affidavit, there would also be a requirement of past reliability being shown, which was never shown in this particular affidavit. And then if you don't have past reliability, you can have corroboration. But the police really did no investigation.
I mean, most of those cases that deal with past reliability are dealing with an undisclosed informant, right? I mean, there's certainly, that doesn't apply in a citizen informant. If somebody calls the police and says, I'm looking out the window in my neighborhood and I see this black car that's doing, committing, the occupants are committing a crime, there's no requirement of corroboration in that circumstance, right?
Well, I think that and forgive me because I can't recall the case, but in my brief, I think there was a couple of cases that I cited where the informant was named. And
yeah, I'm talking about a citizen informant, though. What they call a good citizen informant. Usually,
right.
Usually, an eyewitness to a crime that gives his name and address to the police. There's no corroboration requirement in that, right?
No, there wouldn't be in that kind of situation.
Right.
But again, this Delaware case, I think, is kind of informative because it talks about the fact that they're not your average law-abiding citizen when they're cooperating with the police. So I think they're held to a different standard because obviously they have a gain. In this case, he had a gain of not being prosecuted for a number of different kinds of federal charges potentially as well. And so my position is that the Blue versus State 441 Southern 2nd 165, they said to place our imprimatur on the warrant in the present case would be to sanction a search in every instance where a person of unknown reliability brings contraband to the police, tells them that he obtained it in a particular place, and that there is more where it came from. And they said this is not the meaning of Illinois versus Gates. And that's the situation that I believe we have here. We have an individual without any corroboration who says this is what happened after he's given 5 different statements about where this money came from, and they're supposed to believe that there's more where this came from. And, sure, hindsight is everything. The end sometimes can justify the means, I guess. But if we're looking before the end, which is what we should be looking at in the case of an affidavit for a search warrant, then you have to look at what the Four Corners says and what information and circumstances were surrounding that affidavit. And in this particular case, there was no reliability that was ever established to be able to rely on this information. That didn't even get to the point where there was not really a nexus between what he said and what was found in the apartment. Yes, maybe they got lucky and they did find something in the apartment, but how many times can that happen where something might not be found in the apartment? To take this to its end would seem to indicate that anytime anybody's arrested on the street, a police officer can say, well, There might be a receipt that would show that he didn't own that property in his house. There might be something in his house. There might be something
Well,
else.
there's quite a bit of authority for that, for the fact that the issuing magistrate may infer, when it's established in the affidavit that someone has committed a crime for which there are probable fruits or instruments, that it's a reasonable inference that the fruits or instruments of that crime, of that criminal behavior are kept in their dwelling, right? I mean,
But I would submit under Florida Statute 933-18, which seems to be a different standard for searches of people's homes and residences, the statute specifically requires that there be facts supporting that probable cause. And to just allow an inference...
well, but these are facts. In other words, if there's a fact that establishes that somebody's a drug dealer, that's a fact. Those facts that establish, if you take that as a given, we all can infer from that if someone is a drug dealer, that they're going to possess drugs from time to time, and they're going to possess the proceeds of those drugs, which they're probably not going to put in the bank, and they're probably, it's probably cash, right? And they're probably going to keep that stuff where they live, or, someplace where it's safe, right?
But does that mean that somebody who gets stopped for, let's say, a possession charge on the road? Okay.
Maybe not, but you have to look at what the crime is and what those facts are. The magistrate's entitled to draw reasonable inferences,
Sure.
right?
But I think the case law seems to be, and there's a lot of the cases that came with the child pornography cases and versus the drug cases, but it seems that most, if not all, of the drug cases, at least that I was able to find, the Coronado case, the Diaz case, the Thompson case, the Howard case, were all dealing with situations where the police said, okay, this guy's growing marijuana in a shed, does that give us the right to go in the residence? This guy has got, a couple of houses, does that give us the right, or he conducts a transaction in a parking lot of a grocery store, does that give us the right to go into the houses? And so there's a distinction, I think, in the drug cases, or seems to be, that the inference is allowed, but there's got to be some supportive facts under 933-18 that would allow a person to be able, or the police to be able to get a search warrant for that particular house.
What you had in this case was some materials in the affidavit from the detective about how drug dealers work, and they normally do keep some at their place for smaller transactions, etc. Does that make a difference? Was that the case in any of those drug cases where the courts held you couldn't go look?
Yeah, there was one case that I'm trying to find here. There was one case where they were talking about the experience of the officer and that not being sufficient. I think it was the Burnett case. Yeah, the Burnett versus State 808 Southern 2nd, 1170. That case, in the affiant put in there that based on his experience, other evidence would be found, and they found that that was insufficient. Because it's conclusory. What was put in this affidavit, there wasn't any facts that he just said based on my training or based on my experience. But what experience, what training, what specific training manual is saying that? I mean, it just opens the door to a police officer just putting vague conclusory language, which is not allowed, without any articulable facts under it to support it, which wouldn't comply with Florida Statute 933-18, which in its very terms requires specific facts. In this case, Mr. Michi admitted that he never had been to this apartment. There was no indications that the apartment was involved with anything other than the speculation of the officer. And under the Diaz case, the court said inferences that drugs might be present are nothing more than speculation, unless there's facts to support it. And in this particular case, there was a complete lack of facts to support it. And that's why we believe that the circuit court, the trial judge in this case, after 4 days of hearings and plenty of time to think about it, addressed the situation the way she did in her order granting the motion to suppress. I don't know if there's any other questions.
Okay, thank you.
Thank you.
I'd just like to clarify a few things. First, Mr. McShee had nothing to gain at the time that he made these statements. He'd not been offered immunity. He'd not been offered anything. And as a matter of fact, it seemed like the police officer who took the statement thought he had a real coup over him and his attorney when they came in, because he said we let him go because we had nothing to hold him on. The facts in this affidavit also establish that Mr. LIBURDI was a drug trafficker, which is very significant in a lot of the cases from
You just said that
other...
he got let go because there's nothing to hold him on. Before you said these were statements against penal interest. What establishes his reliability here? I mean,
They had
first
nothing
you
to-
had the statement against penal interest, and then you had some facts that pretty much anyone could come up with. I mean, it's not, the fact that you know where someone lives or what kind of car they drive or that they're friends with someone else is not particularly strong verification that someone's engaged in criminal activity. Would you agree with that?
Yes, but he did have $103,000 with him too, which is not many people drive around with
Right.
and the smell of
But as far
marijuana
as-
in his
but-
car
but
too.
as far as putting the blame on Mr. LIBURDI, that Mr. LIBURDI was a drug dealer, what facts establish his reliability as far as that statement?
He had no need to explain away $100,000 though. They had no evidence that he was involved in drug trafficking at all. They suspected that he was, and he came in with his lawyer and admitted that he was. And then in Walton County, they passed the information down to Orlando. They said they didn't pursue any charges up in Walton County. They sent everything down to Orlando for further investigation.
He put the blame also on someone in Colorado, correct?
He was living in Colorado,
Right.
I
As
think
far as
initially.
someone- Yeah.
And he was I think he was getting the marijuana from Colorado. Yeah, he was. He was getting the marijuana from Colorado and bringing it to Florida. He was providing Mr. LIBURDI with the marijuana, so
Is there any indication whether authorities checked that person out? Anything in the
that I don't
affidavit
know,
on
no.
How do you distinguish the drug cases opposing counsel refers to where, you find the pot growing in the field, that doesn't necessarily let you...
Search the residence?
Yeah.
And that one case, I believe it's a second DCA case, and they said there were no allegations in the affidavit. I think we have sufficient allegations in the affidavit
That
here.
was a sniff case. That wasn't a drug dealer. Coronado was, they smelled marijuana in the shed, and then they went and searched the house. That was not a drug dealer case. That's how you distinguish it, right?
Oh, yes. Yes, but I was thinking of the ones where, here there's evidence he's a drug trafficker, and that's usually what most of the cases require. All the nexus cases from the federal courts and from the state courts, when you have a drug trafficker, you can infer that there's going to be fruits of his crime in his residence, and that's what we're relying on. And we would ask this court to reverse the order of the trial court, also on the good faith basis, if this court finds that there wasn't a specific nexus, because since this search would have been good in many jurisdictions in this country, I think the police had a good faith basis to rely on it. Thank you.
Thank you.
Counsel.